was substantial, and our client was extremely pleased really hard. And it was hard because it involved serious allegations of sexual harassment and retaliation. Or didn't file a lawsuit right away, and we held off, and we put together a comprehensive demand letter. So it laid it all out for the employer, and we tried to set up a mediation, and were successful in doing that. We actually were able to resolve it within 3 months of the termination, which is extremely rare, but in this case fortunate for the employee. And she had worked at this company for a very long time. It was close to 14, 15 years. The employee was terminated because she refused to continue an affair with her immediate supervisor. They were having a relationship, and this went on for a period. The relationship ended, and my client wanted to end the relationship. Her supervisor did not want to end the relationship. That's where we had the friction. Told, and this is confirmed in emails and texts, that he could no longer work with her. Well, that was a bad situation. The supervisor would either be extra nice, trying to get her to get back into the relationship, or on the flip side, he would berate her in front of other employees, send condescending emails and texts, and calling her names. Well, she calls it off. They were getting along fine. But one of the other owners in the company said they want to have a face-to-face meeting, and at first they decided to change her hours so that the immediate supervisor wouldn't see her at the office. That didn't work, and that wouldn't work. To actually telling her she was going to have to leave, and they offered a number of legal claims. There was wrongful termination in violation of public policy. Mean if you turn your employer in for violating OSHA requirements, or if your employer retaliates against you, that even though she has some involvement, obviously, in the relationship, she was never forced into having any type of relations. Once she asked for it to stop, then the California law kicks in, and now they're unwanted sexual advances. And that's where they had the problem, because the immediate supervisor couldn't handle having her in the building because he couldn't have her. She tried to end it before, a number of times, and it was made clear the very first time that, well, if we can't have a relationship anymore, then you're going to have to find somewhere else to work. And the breach of contract is, usually we don't see this, but we actually have text messages from the supervisor and other owners of the company saying, we would never think of firing you. We want you to stay here forever. All kinds of things like that. So what that did is it created an implied in fact contract, as opposed to having some written contract that lays out the terms of your agreement at will in California. But there are instances where over time, if promises are made, your job's secure, you're doing well, we promise you can retire here, things like that, that create an expectation in the employee's mind that they're going to be kept there and they're not going to be terminated except for cause. You can have a binding implied in fact contract, and that's what we had here. My client is a single mother of 2, and she cares for an elderly. Very difficult, and it was very difficult for her to go a month without pay, let alone 3 months. And in this particular instance, because she had tried to end the relationship, and he told her, you can't work here anymore if we end the relationship. Well, what that is in California, that's quid pro quo sexual harassment. That is, you cannot have your job, you cannot keep your job, you cannot keep these benefits unless you agree to have a sexual relation. Their job is something that they would be willing to do a lot of things. And unfortunately, there are cases where people are forced into having inappropriate relations with their immediate supervisor so that they can keep their job. Because in this instance, there are also issues where previously her immediate supervisor and one of the other owners had told her she was going to own part of the company and that she was going to be part of profit sharing. That never occurred. Went through the records, we realized that the company basically was expensed out, though the company that she was supposed to be sharing profits in, expenses were being paid for employees in the other company, which would bring the profits down, And at the end of each year, gosh, we didn't make any money this year, so you don't get to share in the profit. Mediation, we agreed to go to a neutral site here, right here in Orange County, and had a professional mediation to work. You have to have everybody there. You have to have the decision makers there. We actually mediated this case for close to 3 weeks. Both sides were pretty well entrenched in their positions, and it took a while. The other side had to come to grips with the fact that there was significant exposure. These claims that we had carried attorney's fees. And in a case of this magnitude, an attorney fee provision, it could be upwards of $250,000. Having the right to recover attorney's fees was a big factor. Multiple mediation sessions. So that slowly got the parties moving a little bit closer to resolving the case, which admittedly in everybody's best interest. This was not a good case for anybody to be publicized. We had an Olympic athlete on the other side, world famous. Anything like this coming out in the media would be, I would imagine, close to catastrophic. That's why we tried to go with the settlement route before filing suit and making this a public spectacle, which we were successful. Settled the case. It's a confidential settlement. I'd have to pay 5 figures if I said on this camera right now what our settlement amount is. No risk, you know exactly what you're getting, you're able to collect it, and you can move on with it. That was one of the issues that was brought up actually in the mediation, where the other side said she did it voluntarily. And our point was, well, wait a minute, in California, the law is you don't have to have sex with someone to keep your job. And just because there was a relationship before that, and it was voluntary, when she no longer wanted to have the relationship, that's when it became a problem. Part about this mediation is usually mediation occurs after you've lived and breathed the case for 6 months to a year. And so then you know everything about everybody, and you've taken depositions, which are sworn testimony under oath, and you've pretty much found out everything there is to know about the facts of the case. And in this instance, we didn't have that. So we were really learning the detailed facts and the intimate facts, no pun intended, on the fly. And maybe that's why it took a little bit longer for things to sink in. It's nice every once in a while you can actually get together, resolve a case. It wasn't easy, but we did resolve it without having to file a lawsuit. The irony of all this is she ultimately got over 3 times what she had asked for early on. We analyzed the facts and we analyzed her conduct. There were all kinds of violations. I mean, there was sexual harassment, there was retaliation, there was disparate treatment, there was breach of contract, and there was discrimination. There's also the hostile work environment, which was one of the other issues that we had in this case. And that's when the employer decides, well, I'm going to make them quit. I'm not going to fire them. I'm just going to make it so miserable here that they have to quit. Sexual advances being made by the immediate supervisor. In this instance, we actually had something I'd never seen before, and that was an email from the immediate supervisor telling our client, I'm sorry that it happened, and from here on out, the inappropriate advances will cease. It certainly was the equivalent to a smoking gun in this particular case.